Good morning, I'm Kristine Lehmann. Now this morning we're being graced by the presence of Frank Higginson. Now Frank's an incredibly well-known solicitor from Hynes Legal. He and his team put together about 15 to 30 settlements a month. Those are huge numbers. Frank is one of the most approachable lawyers I know. He can make any complicated issue seem very solvable and quite easy. So Frank, off to you.
Welcome. So I suppose today we're talking about topping your agreements up and variations to them. So I suppose the starting point for me is for everyone to understand the difference between a top-up or a variation and exercising an existing option. So what is really important to understand is your existing management rights agreement will be for a finite term. That might be 10 years, that might be 25 years, and that term could be broken up into a 10-year term with a 15-year option, or a 3-year term with a 4-year option and a 3-year option, or whatever it might be. So today's topic for me is talking about creating further term at the back end of that. But what everyone out there should understand at a very preliminary basis is what your actual agreement consists of at the moment. Because sometimes you need to physically send a notice to your body corporate to exercise an option, and if you don't do that, the agreement comes to an end. So that's not what we're talking about today, but it's important for everyone to understand the difference. Yeah, absolutely. So, and those options are really important things to get right. So again, I can, in 5 seconds or less, I can tell people what their agreements are if they're not sure. And certainly from our perspective, when clients are buying, we tell them the difference and what they need to do and when, but it's very easy to forget. You know, because a term might be 10 years. You know, you buy that with 6 years to run. Today, you don't have to exercise the option until 2020. So who knows what goes on between now and then. So they're really important things to diarise.
Why is it important to actually top up these agreements?
And I'm not a valuer, but the key thing for me, the valuers will tell you that certainty equals value. So in a management rights context, what you're selling with your business is the goodwill that is derived from the income the business earns. So your net profit of $100,000 is tied irretrievably to the remaining term of your management rights agreement. So in a valuation context, if you've got an agreement for 1 year with $100,000 worth of income versus an agreement for 25 years with $100,000 worth of income, there's obviously a substantial difference in the value of that business. So the more term you can have, the better off you are. So it's really important for clients to understand that they should be looking at this, to me, at least in an accommodation module building, at least every 5 years, because you want to stay as close as you can to 25. And in standard module buildings, it's probably really, you don't want to let it get less than 8 or 7 years. Like from my end, sometimes clients find it a bit difficult to ask a body corporate every single year for another top-up to get from 9 to 10, 9 to 10 and so on, but certainly you want to do it every 2 to 3 years. And sometimes in a standard module building, the banks give you the prompt to do that because they might change your repayment obligations from an interest only to a principal and interest. So there's an automatic trigger for you to deal with it. In accommodation module buildings, that's not necessarily the case because of the longer term, the banks can usually do interest only. So even if you've got 18 years to run, well, absolutely that's a long time. 23 years is better. And 25 years is, again, incrementally better. So staying on top of that and understanding that you should do it is the starting point.
Have you come across a lot of people who've actually forgotten to top up?
Yeah. We had a client a little while ago who let his 10-year agreement run down to 6 months. So, and he rang us out of the blue, Frank, this is where I'm at, this is what I need to do. And it's sort of obviously he mustn't have borrowed too much because otherwise his bank would have been well and truly up his ribs. And as it turned out, he got away with it, which was great. And he'd been there obviously for 9.5 years, so had a relationship with everyone, had done the job pretty well, so didn't have any difficulty. But if his relationship with his body corporate and his committee wasn't good, you've got 6 months worth of management rights agreement left to go.
Obviously that story ended well. But if you have a body corporate committee that isn't exactly as pliable or friendly, it would have turned out differently.
Absolutely.
So can a body corporate committee actually say no?
Yes. So, and this has absolutely been litigated before as well, where a committee has to act reasonably, but by the same token, they're entitled to put forward their opinion and their recommendations to owners. So it is well within the rights of a body corporate committee to write to owners and say, we recommend you vote no to this variation. So, so the legal side of things in terms of topping an agreement up, not necessarily difficult. You know, like really it costs somewhere from probably $1,000 to $1,500 for us to do the complete package. So it's not expensive in relative terms.
Not at all.
But it's important that the commercial side of things really gets managed. And the commercial side of things for me is not simply the legal documents, it's understanding where you stand with the committee and your owners and all of that sort of thing internally. So handled wrong, it's all well and good for you to put a motion up, but if you haven't communicated with the committee about why you need it, or your owners about why you're looking for it, and then you've got some undue influence in the committee who's not necessarily pro-management rights, it can actually turn pretty ugly pretty quickly.
Exactly.
So for me, when you are going to do one of these things, you want to engage at least with your committee, your chairperson, whoever the important people are that you deal with on a daily basis, to let them know what you're doing and why, and if there's any resistance, then we start to manage the process then.
I've got it.
Yeah.
Why don't you take us, I mean, a lot of people who are going to be listening to this are actually inexperienced. It's probably their first year on. They don't even know what the process of topping up an agreement is about. Could you take us through a step-by-step?
Yeah, cool. So from a body corporate perspective, every year it must have its AGM. That AGM has got to be within 3 months of the end of the body corporate's financial year. So a body corporate's financial year is not tied to our tax year. It's not 30 June. It can be the end of any of those 12 months of the year and comes back to originally when the thing was first registered. Either way, it's all part of the body corporate records, and that's what the budgets are built around and so on. So what will happen is your body corporate manager will write to every lot owner in the scheme about 6 weeks before the end of financial year. So if it's 30 June, the end of financial year, you'll get a letter mid-April saying, hey, do you want to nominate for committee? And of course resident managers can't, but all the other lot owners can. And do you want to put any motions in for the AGM agenda? So that normally is the trigger for people, hang on a minute, what do I need to do? So you get an automatic invitation to do it. For us, I always prefer to see a variation motion or a top-up motion in the AGM agenda, because then it can get lost in the mix with all of the other motions. So there'll be the usual statutory motions about it, confirmation of minutes, adoption of budgets, do we audit, do we not audit, whatever else might be on there from the committee, and your motion then gets lobbed in the back. It's a secret ballot, but it's one of 20 or one of 15, whereas if you do it at an EGM, which is basically called for that specific purpose, there's one motion which is confirmation of the minutes of the last meeting, and then yours.
Okay,
so
so
everyone's
you want
attention.
It in the annual general meeting, not in the emergency general
Absolutely,
meeting.
So you don't want it to be the sole point of focus, which is what happens at an EGM. So, so you get that trigger. The way it works is if you submit a motion before the end of financial year, it must go on the agenda. The body corporate can't say no. So the difference between an AGM and an EGM is that an EGM, you can't get one called unless the committee agrees to call it, or you get the support of 25% of lot owners. So
Again,
perfect world. Yeah, absolutely. And the other thing, body corporate managers will sometimes try to get you to pay the costs for the secret ballot and that sort of stuff. They can't.
Oh, that's new to me. Yes, I've heard it said that it was such a huge cost to get this topped up. Okay.
Yeah, and again, so that's not to say you wouldn't do it if asked and handled the right way, but from a statutory perspective, they can't make you pay for it. So you put the motion in, it must go on the agenda, and whatever the costs are of dealing with that are a body corporate expense, because that's your right as a lot owner. So once that goes in, normally what will happen if you, and this is where you want to understand where the committee sits before you lodge it. So to me, you're back one step. You've got your letter on the 15th of April to say, hey, you've got 6 weeks to get motions in. Starting point would be to understand whether you want to do it or not, whether you want to top your agreements up so that, take it 25 to 10, whatever it might be. If you do, the legal documentation, like I said, isn't necessarily complex. It's a motion. You need to have a deed of variation that actually correctly creates the further option term. There's a statutory document called the BCCM 20 that sets out a summary of basic parts of the management rights agreement that you're seeking to change that needs to go with it. And that's the legal package. So it can be done relatively quickly, not that complex. So how we would normally suggest clients deal with it would be come to us, we draft the documents, we get the client's approval of the documents, and then you have the conversation with whoever you need to have the conversation with. So your chairperson, your body corporate manager, your committee, to say, guys, this is what we're doing, this is why we're doing it. We're going to lodge these documents in 3 or 4 weeks' time, just letting you know. And what that does is sort of throw it out there for people to blow up if they're going to blow up, or have the conversation with you if they don't like it. And that then gives us the ability to perhaps shape it a little bit, respond, withdraw, put it forward without any difficulty, knowing we're going to get there. You know, so for example, so again, there's this legal and commercial thing for me. The legal is we put the documents in, the commercial is how you actually get the outcome.
Yes.
So sometimes a committee will want to negotiate the terms of the variation, so they might want to add an additional condition. Some agreements, if you're one of those rare managers out there that has an annual remuneration review to 5%, quite often when you go to top agreements up, if the committee's live to it, they may want that to come back to CPI. So, you know, you might get a response from the committee to say, hey, we're happy to do that, provided that you knock your 5% increase down to CPI. And in that circumstance, for me, that's a pretty easy give. Some other ones we've done in relation to new agreements, we might provide a salary freeze, or we might do a half CPI increase for a period of time. So, because I mean, there's nothing in a sense, body corporate gets management and it gets secure management, but there's not a whole lot in it for it otherwise. And ultimately, money talks for a lot of people. So little gives like that actually help get these things across the line. So that's why, for me, it's better to engage with the committee beforehand rather than lob the documents in and then have the discussion. Say, here's what we're going to do. You have the discussion if there's anything to be had. Draft that so it's agreed, and then it goes up with the endorsement of the committee. And probably, if there's one thing from my end that's worth its weight in gold, it is that. Committee endorsement to your motion will almost guarantee its success.
Correct.
So, so if you have to give away a 2% increase over a period of time to get that, to me that's a sort of small price to pay for the additional term that you'll be picking up.
Okay. Now this is different from putting in an option.
Correct.
In other words, when you put in an option, there is no choice. They actually have to go ahead and agree it.
Yeah, correct.
Agree
So,
to it.
yeah, so what you'll have in your management rights agreement, your option will be, provided you give a notice within a certain period, the body corporate must grant it. The committee can't say no. So that's done at committee level. That's an easier process again, but you just want to make sure you give that notice. And these variations, or the top-ups I'm talking about here, they need to be approved at general meeting level. So they've got to go to all owners. There's no shortcuts about that. The Act's very prescriptive.
You can't do it with a committee. A committee cannot top you up. It has to be an AGM.
Correct. So they can endorse you and they can support you, and the same as they can vote against you, but it has to be at general meeting level, and it's done by secret ballot, which means that the votes go to a returning officer. No one knows what's happening until the day of the meeting. And if you go to the meeting, and you should if you're a manager, you'll see the returning officer in a box in the corner. They'll start pulling out ballots, opening it up to show that Kristine of Lot 1 voted. Yes, she's financial, tick. And they'll pull the ballot paper inside another envelope out, put it in that box. And once they've gone through all that, they mix them all up, and then they open the ballot papers. So there's no way to know who's voted which way. So that can be good or bad. You know, if you've got a militant committee but owners support you, you may well do okay. But by the same token, you can have owners tell you to your face they're going to support you and then vote against you, and you don't know. So it is, and for me, probably the most important thing, and this is in life generally too, it's management rights is a relationship building exercise and a relationship management exercise. So you don't want owners to hear from you for the very first time when you're writing them and say, hey, please support my variation.
Exactly right. Exactly. And how do you suggest people communicate?
You should be writing newsletters.
Okay, Frank, tell them. Tell them.
You should be writing newsletters. When you're asking for favours, for me, it doesn't work when it's the first time you've actually communicated with people. End of story.
I wholeheartedly agree.
So newsletters, it's not that hard to do. And Raz has with Mike Butler a wonderful wordsmith, a fully qualified bush lawyer, who sends out stuff every month. It's just so people want to know what's going on in the market. So for me, a couple of things. Newsletters should go to all owners. I wouldn't, as much as your investment owners are critical to the value of your business, those guys you should love and they should know that you love them. You should be writing to everyone else as well with stuff that's topical. So, I mean, at the moment in Brisbane, G20's looming. So anyone who's got a corporate building in Brisbane should be writing to all owners about G20 to show they're on the ground, they're interested, they're engaged, what's going on with the building, what's going on with Brisbane, and so on and so forth. So that it actually just shows you care. And it shows you they're doing the job.
Well, thanks for reinforcing the whole issue with newsletters, because that's one of my pet loves. Is like I really, really reiterate to everybody consistently that you really have to communicate with all the owners in the complex, not just your investors, and not just when you're looking for something. Yep. And keep them top of mind. Let them remember that you are in real estate and you sell. So. And
that's what our newsletters do as well. Exactly. Every month, every client hears from us. Yeah, so they remind who we are. Yeah.
Sign up to both newsletters. Yeah. Okay, so Frank, we had the call for an agenda. So we submitted our motion to say that we were going to top up the agreement. We've had the paperwork drafted by a competent, well-known expert in the field to actually put the variation together, and we've taken that to the committee and they're now on board, and now the meetings happened. What are we looking for? Are we looking for a majority, or are we
ordinary resolution? So in body corporate land there is no compulsory voting. So in a building of 100 lots, something could be passed by 1 vote to 0 and it's a valid resolution. So from a lobbying perspective, if you need to lobby, it's really important to understand who votes. There are people that won't have voted in their entire ownership tenure, and there are people that vote every single year. Correct. Those guys who vote every single year are the most important people for you to understand whether they support you or not, because you know they're going to cast their vote. So ordinary resolution is simply more votes for than against of the votes cast. Excellent. So 100 lot building, 5 votes cast, 3 in favour, 2 against, you win.
Amazing.
Yeah.
Okay. How about proxies? Are they allowed to solicit proxies?
No.
I get asked that all the time.
Yeah, absolutely. So proxies in Queensland are really hard to use at the best of times, but they're specifically prohibited from being used on management rights agreements and committee elections. And the other thing is you can't actually use them on a secret ballot because you need to identify who the proxy holder is, which the secret ballot doesn't allow you to do.
Okay, so how about if you have investors that can't be in the building?
They need to send their voting paper in. So what they'll get is, with their agenda, they'll get an open voting paper, which will be minutes of last meeting, budgets, audits, etc., and they'll have a secret ballot voting paper. They need to tick the right box, put that inside the little envelope, put that then inside the other envelope to go back to the returning officer and send it to them. So unfortunately, and it might be coming, we haven't got electronic voting yet for motions in Queensland. It will come, but it's not here yet. So it's a laborious process in a sense where you physically got to tick the box, take it, post it, but there's normally a 3-week window to allow that to happen. So it's important for managers who have investor owners that aren't actually local to send that back in. I mean, and I've actually had one client in a very contested top-up physically flew around Australia to meet with all of the investors to help them complete them, and then they posted them in. Because the other thing you can't do...
That's being proactive.
...is collect votes and put them in yourself. So there's a real... that's been litigated as well. Owners must be completely independent in sending their material back. So you can't walk around, collect 8 votes and then post them yourself because they're all invalid.
Okay. But here's another point I want to stress. Basically, these investors are trusting you to manage their massive investment. Why shouldn't they trust you with a vote? So do give them a call, create a relationship to ensure that they actually fill out that ballot and vote in your favor. Okay, Frank, you've had a few stories in the past about people who've tried to do this themselves, tried to put together their own variation or do the legal work behind it. Do you have any stories you want to share about doing this?
Well, where do we start? The people get it wrong. And I suppose I try to make it sound simple. And in some of the stuff we do, it is, but it's still not an easy job. And I suppose when I've done 1,000 of them, you know what you're doing. They keep trundling through. I mean, we had a deal where we had to go get new agreements just literally this week, where the manager had done 2 variations themselves and they hadn't even included the statutory form that you're required to do. So, whoop, fatal, end of story, no choice. So they basically lost 10 years of tenure because both of those previous variations were invalid, let alone the detail in them. Sometimes, and you need to actually look at the agreements when you're varying them, because how the remuneration gets adjusted sometimes isn't necessarily reflective if you create another option term. Getting the dates right, clarifying any issues. And the thing is, it's all well and good for them to be passed, but the test is when it goes through due diligence from a sale perspective, when we're looking at it for a buyer and when the bank's lawyers are looking at it, because again, back to what we said at the very start, certainty equals value. If the term's not there, you guys might have sold something that actually
doesn't exist.
Yeah, so this particular deal, we were 10 years short of what we thought we had, which from our client's perspective as buyer was, well,
What are we
No,
selling?
yeah.
Yeah, what are we selling?
I'm not proceeding on that basis.
At all, no.
So back to general meeting, they're going to have to go and sort it out and run the gauntlet of the body corporate. And this manager's been there for years, so I suspect they'll get there. But, and as lawyers, you always look at the worst case scenario. Worst case scenario is positions change, you've got a militant committee, you've gone and wound everyone up unnecessarily, and then suddenly you ask them for a favour. It's not the best position to be in. So do it once, do it properly, get it right, and don't worry about it ever again.
So actually this is, when you say that it costs about 1,200 to 1,500 to do this, it's a pittance compared to what could actually go wrong.
And to me, I always look at it in terms of, you know, I suppose in business and life, it's sort of risk and return. The risk is you're paying us $1,000 to do something. The return you get for the additional term, to me at least, is a lot more than the $1,000 you pay.
Leave it to the experts.
Yeah.
You continue managing your resort, you do it well, that's your forte. But when it comes to legal issues, please count on the experts.
Yeah.
Frank, thank you so much. I actually wanted to ask you this. The industry not know anything about Frank Higginson.
Lots, and that will remain that way. No, I suppose it's probably the approachability and contactability, I think, for me, as I try to push. I answer my own phone calls. I do a lot of my own emails. I do a lot of my own, do my own work. And all we do is management rights and body corporate. I'm not interested in being anything else. So yeah, sort of living and breathing every day this stuff. So I probably do make it sound a bit simpler than it sometimes is, which is a little bit
which helps for people like me. You dumb it down for me.
Yeah, I'm a normal person, I suppose. I'm not a lawyer, I'm a normal person. Yeah.
Yes, but I will vouch for that. Basically, every time I do call, and I'm sure he does the same with his client base, every single phone call does get returned on the same day. So if you're looking for somebody to count on, an ally in this industry, I really wholeheartedly endorse Frank. So thank you so much for being here. I really appreciate it. It's like pearls of wisdom.
Thank you for having me.
Thank you.
Good luck, everyone.